It was supposed to be a quiet technical sitting. 2 days only, no grand verdicts, no victory speeches on the courthouse steps. But when the High Court in London reopens the folder Harry v. Associated Newspapers, publisher of the Daily Mail, even the word procedural sounds like a flick to the industry's nerves. In the room sits not just the Duke of Sussex. Lined up beside him as claimants are names that make editors' blood pressure jump on sight: Sir Elton John and David Furnish, Liz Hurley, Sadie Frost, Baroness Doreen Lawrence, Sir Simon Hughes. On the defence bench, one of the most influential media houses in the country. And the stake here, honestly, isn't only money. Strip away the theatre and look at the structure. The group of claimants alleges that Associated Newspapers Limited, ANL, commissioned or condoned dirty newsgathering, everything from placing listening devices in cars and blagging confidential records to theft to order and intercepting conversations. ANL calls the accusations extravagant and wholly implausible, insisting the stories are not just exaggerated but simply untrue. This round is about preliminary issues. Mr. Justice Nicklin will sketch the battlefield, decide what will go to trial, how disclosure will work, and what evidence is admissible. Formally, no guilt or innocence is being decided now. In practice, this is where the court decides whether either side will be handed a sharpened blade for the final bout, penciled in for 2026 and potentially stretching to 9 weeks. The case has a timeline as long as a newsroom's overnight shift. Back in November 2023, Justice Nicklin swatted away ANL's attempt to shut this down pre-trial on limitation grounds. In spring 2024, the government eased restrictions on use of Leveson inquiry material. Documents concerning Daily Mail payments to private investigators got a green light for disclosure in the Duke's claim. That's not a footnote, it's a potential bridge into an archive from an era when tabloids and private ears often ended up in the same pub. But the claimants have sore spots of their own. In July, the judge ordered Harry's side to disclose documents about payments to potential witnesses, after ANL's lawyers said in May they had seen paperwork showing payments made or offered for obtaining information and accounts. The court's language was curt. The claimant's disclosure had been inconsistent and incoherent. Translated from legal to human, if you're going to charge others with unclean methods, your own hands must be spotless. The court wants not only proof of the other side's conduct, but also the claimant's own transparency. Money. That's its own ache. In January, the court criticised the parties' combined costs budgets over £38.8 million as plainly excessive and disproportionate. In modern British litigation, such numbers are like an interrogation lamp. They illuminate not just the scale but the toxicity. The more expensive the case, the greater the temptation to turn it into an endurance match. Whoever pays longest wins. The judge can see that and is leveling the field. If this still sounds like legal accounting, remember how often procedural knots have strangled headline media trials. What gets admitted into evidence is what 2026 splash pages will feast on. Will Leveson-era material be allowed? How deep will the court let lawyers drill into invoices, ledgers, and receipts? Where is the line between methods that now repel and the then commonplace everyone did it? Strategies for both sides, and the next decade's journalism ethics classes, are being sketched around those questions. For the Duke of Sussex, this isn't the first in a series, but it may be the most systemic. Against Mirror Group newspapers he already secured £140,600, with the court recognising unlawful information gathering. With News Group newspapers there was a substantial, and sealed, settlement in January. Those outcomes cast a precedential shadow. The claimants enter a new courtroom carrying a portfolio of wins. But Associated Newspapers is a different house with different editorial habits and a different defence line. That is why this action could become the case of the decade, not about one title, but about an industry of habits. There's another, oddly political layer. In November it emerged in court that Baroness Lawrence learned of a possible claim from a text by the Duke in January 2022 and soon met the same lawyers he was using. For the defense that looks like coordination of a front and an excuse to dig vigorously through the claimant's communications. For the claimants it is simply harmed parties exchanging information about identical practices. Again the court cuts out the emotion and asks for documents. Crucially, Justice Nicklin wants a systematic, spreadsheet-ready approach to disclosure without which any narrative will crumble. What happens over these 2 days? A blizzard of dull words: admissibility, timetable, scope of disclosure, standard of proof. Don't be fooled. These dull terms decide whether in 2026 we'll watch 9 weeks of documentary avalanches or face a blank wall of procedural refusals. For the press, it's about whether and how they can tell the history of the hacking privatize era from ledgers rather than memoirs. For the star claimants, it's whether they can translate lived trauma into justiciable claims. For the Duke, there's a reputational stake as well. Around his name a hard binary has long been framed: fight for transparency versus personal vendetta. Every new case risks cementing one reading. Victory bolsters the argument that this is a structural challenge to dirty methods. Defeat hands ammunition to those who see a crusade against an inconvenient press. That is why Harry's team obsesses over procedural hygiene. Courts run on verifiable facts, not feelings. For Associated newspapers, this is also a moment of truth. Their public line is tough and confident, they're minting sensationalism, stretching beyond reason, much too late. But the court has already rejected too late and opened the door to Leveson archives. That means the defense standard must be higher than don't believe them. It needs forensic rebuttals, expert evidence, and immaculate procedural discipline. Otherwise, in the public square, Association will begin to do the work, and in 2026 that could cost more than any damages award. The most awkward element is the long fuse. A 9-week trial 2 years from now is a whole media political epoch away. Britain's news landscape may look different by then. But precisely these cases shape that landscape. If the court reaches substance and pins down legal definitions of permissible methods, editors' handbooks will be revised along with compliance checklists and insurers' clauses. If everything dissolves into procedural fog, the industry will receive another expensive reminder of the price of business as usual. For now, the hush before the bell. Justice Nicklin will set the rhythm. Counsel will test each other's transparency. Newspapers will count column inches. Everyone will pretend this is just a stage. The truth is that on exactly these stages it's decided who will eventually say, "We proved it," and who will say, "We survived." In the British justice system, those are different genres, and they carry different price tags. One question keeps pulling the audience back to Harry's litigation: will it be for real this time? The answer is unromantic. For real means dull tables, payment chains, cross-examined experts, and thousands of pages of disclosure checked line by line. If those bricks stack, then yes. And then we move closer to what the tabloid era hates most: bright lines. Who, how, and at what price gathers a story? Where the public's right to know ends and the individual's right not to be broken begins. That is what this new round is about, even if the diary entry says only 2 words: preliminary issues.